about part 8 by now. This is going a long time. I'm trying to get this over with. About 6 months after my brother passed away, he was in a liver coma, 3 weeks unconscious. I was there 24/7 because I feared for the safety of anyone, because I fear for the safety of anyone in the hospital, not because anyone is against him, but if there's a witness, there's liable to be less disaster in the middle of the night. For example, I have nothing against nurses or doctors, it's just a situation. After this 3-week coma, while I was there 3.5 weeks, I thought he was going to die, but he miraculously came back. He was unconscious. I asked my sister to call Flora because we had not seen or heard from her daughters in years. And called Flora. She came up to see her father. She agreed to drive from LA one weekend, probably approximately June 2019. She called my brother. They were to meet at the house. There in the street, we were pulling up. She disappeared. Then I think Lee called her, and I called her, and she said she didn't want to see me, that she was going to cancel the appointment because she didn't want to see me. And I hadn't seen Flora in 20 years or something. I'm not sure. So we got her to come back, and I left. I drove off. She was happy. I was happy she was visiting. Exactly an hour later, my brother called me and said she left and that she got on a plane to LA. After that, I noticed my brother's phone would check his calls. You know, he's very old-fashioned, no email, nothing. He would call Flora on Sunday, but it was like a 5-second call. Usually it was him, not her, and I was hoping that somehow they were staying in touch. That was 5 years after 6 months to live. This is the routine. And then he would call and leave a voicemail. It was around this time, just prior, there was a letter came in the mail. And I don't have it with me, but I have it in my possession. And I should have brought it. I ran out the door. It was a big envelope. I have the original envelope. It's dated April 2019. It's not stamped, but it's one of those FedEx things. There was one page that caught my eye, and it said, I can't say my heart verbatim everything, but it says, don't leave the house to strangers. We may need a place to live someday. There's not a lot of tech workers to take up housing in the area. We may get sick. We may die. We may have children. What do you want? It's just my 2 cents. I don't have to present it as a future hearing or pull it up on my phone. Basically, she said, don't leave the house to strangers. We need a place to live someday, and you can do what you want. This is just my 2 cents. And since there was no relationship or friendship between her and my brother, he never saw her since prior to, and I think it was 2014 with this diagnosis. Both daughters disappeared off the face of the earth. And there was another letter where Maxine says, I hope you don't die with regret, but me not seeing you, this is just how I have to go about it. And I believe that these are two things prevalent here: the questionableness of the document itself, as well as the undue influence from the daughters. One doesn't cancel out the other, so I can say that the one hand, I can say that the undue influence, that's not right grammar. They committed undue influence to get him to change his trust. On the other hand, I question the integrity of the trust and the trustee becoming a beneficiary in the second trust, and Mr. Rogers becoming a beneficiary in the second trust. And it's undue influence cases like this that may have benefit the doubt, where the benefit of the doubt is on them. I want to read something concerning that I want to take up on my phone. I believe that contact with Flora, who came up once for an hour, initiated, she was a go-between, and I don't have fingerprints and evidence and phone calls. I'm telling you from the heart, there's some kind of going to be where the deal was where Maxine was going to show up, right? She lived in the Bay Area, but unlike Flora, I believe that something went on between the two daughters. I don't have evidence. It's just my gut feeling. They concocted some kind of deal where if he changes his trust, Flora will come around. Maxine will come and visit. And I remember my brother receiving a postcard and it said, all is forgiven, everything is fine. And my brother had a gut feeling that he was used somehow. I don't know what the real deal was. I just know everything didn't, new trust. I know that my brother told me every day for 6 years, I'm worried about my sisters. They're in their 60s. They don't have education. They don't have any training. They don't have husbands, let alone husbands that are breadwinners. And he felt that since he had to die at such a young age, and since he didn't see his daughters, he wanted to leave something. Objection, Your Honor, from the daughters, for his daughters. This is basically amounts to testimony, and again, this is hearsay. He's testifying about what his brother told him. Sustained. So, Mr. Margulies, I think you heard your evidence and what your evidence would be, and I appreciate that. Okay, may I ask a question? Okay, ask a question. I was handing you to dismiss petitions, remember? Right, and I said that I wanted to delete from the trust contest, like elder abuse, right? Remember when you asked me? That's right, and I did. Is there any way that I could include that by the same token? I don't know what the court mechanism is if I deleted. Is there any way I could add the trustee to this? Because the construction of the trust is only one person that will know if the directions my brother and the trusts were carried out. He's the only witness is Mr. Ferris. I need to put him on the stand and ask him about the things I was reading from the trust. I understand you're asking, can you add a party? Yes. And the answer is no. No way. You cannot add a party. So I've heard from everyone in regards to statements. Mr. Nathan, yes, Your Honor. Now the open statements are closed. I would like to make a motion for a non-suit, and there's nothing that was legally that was shown from what he said, from what he presented. I can't hear. He's making a motion for a non-suit. Okay, I don't know what that is. I couldn't hear you. Okay, just get a little closer to the microphone. Oh, no, say it is. There's nothing in the petitioner's opening statement that will support a verdict of any kind against anybody except he's upset with his brother and his nieces, but that's not what we're here about. So there's nothing legally supporting that could support a judgment. So I move for non-suit. All right, so the court, before the motion on the pleadings and then a motion for non-suit. The court has heard the opening statements, which are not evidence. They are simply what the lawyers say the evidence will show. And is there anything else? Mr. Rogers and Mr. Horn? Yes, I would like to submit a written motion that Ms. Marley is deemed a vexatious litigant for the purpose of having pre-filing orders. We're not seeking any security. We're not looking for a hearing. We just want to put the court review of any pleadings that he files in the future to determine whether or not they're being filed to harass. And I have a copy here. I can hand a copy to Mr. Margulies as well. All right, so that they will need to be filed, and they can't be filed here in court. We can't file, but certainly give a copy to Mr. Margulies. And to the extent that Mr. Margulies in the future resurrects his petitions that he dismissed, then the court would hear your motion. All right, so the matter submitted on the motion for non-statutory judgment on pleadings. Yes. Could you repeat that? All right. This is a 6160. All right. So the court has heard opening statements. As a courtesy, the court wanted to give everybody opportunity to speak. And probate code gives the permanent notifications. Strike that if the notification is served because, let me go a further part. If the notification by the trustee is served because of irrevocable trust or any motion is irrevocable trust of the death of one or more of the settlers of the trust because of the express terms of the trust. The trust becomes irrevocable within 1 year of the death of the settler because, what? The court. If notification by the trustee is served because irrevocable trust or any portion of it has become irrevocable because of the death of one or more of the settlers of the trust or because of the express terms of the trust becomes irrevocable within 1 year of the death of the settler. Because of a contingency related to the death, one or more of the settlers of the trust. Notification of the trustee shall include a warning set out in separate paragraph and not less than 10-point bold face or reasonable equivalent thereof. The state as follows. You may not bring an action to contest the trust more than 120 days of notice by the trust is served upon or 60 days from the date which a copy of the trust is delivered to you. Court has a notification of trustee, has admitted as evidence as Exhibit 61, and the court finds that this notification meets all the requirements, including blah, 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 it's operative language. You may not bring an action in bold type of all caps if the court finds this notification is sufficient. Finds that it is served on Mr. Margulies as well as other parties March 27, 2020. The first filing by this action, Mr. Margulies, was July of 2022, 2 years beyond that date. Mr. Margulies argued that pursuant to the discovery rule, if the harm is not immediately apparent, then the notice period is waived. The court finds that the trust document on its face shows the immediate harm that's apparent, and that is a change in disposition of the trust assets. And for that reason, the non-statutory judgment on the pleadings is granted, and the petitioner to contest the trust and any amendments thereof is dismissed and denied. And then in regards to the parties have told the court that they are intending to file, let's go ahead. Madam Clerk, I'll give you a date. Let's hear it. Court has heard the arguments in form of opening statement this morning. And the court is always aware of the pain the court sees when people have lost loved ones and the reactions people have to each other when they lose loved ones. And although the court is sympathetic to you personally, the court will advise you that you have exhibited vexatious litigant testimony. I'm not ruling on the motion, but the court believes that this matter has caused a lot of pain for you, caused a lot of pain for the other members of the family, and it's best to leave it as it is. Okay. So you're welcome to proceed as you will. May I ask the court a question? No, you may not. We are adjourned. Okay, I wanted to ask about the motion. You may file your we are adjourned. You may file your motion. I wanted to ask a question. You said you have to wait till later. Do you elaborate on that? Okay, I'm going to hear it sooner than later. Doesn't mean you have to refile before I'll hear it. And will I get notice of that? You will. How will I get notice? A proof of service will be sent to you, and it will be a notice on whether the 5 minutes vexatious link. Correct. All right. That would be, and would that be for this case or the universe? A vexatious litigant in general. I mean, you can't Can't give you legal advice. I understand, but I'm slightly familiar with that, but it is. I don't know if you want to answer, but it's applied to this case. When filed another lawsuit, the state of California has a list of litigants. I have to get permission. You have to get permission. So you're going to a hearing about whether or not you're going to need to get permission in the next few months or a year, or the court. All right, Madam Clerk, set for November 8th. The clerk will make a reservation. That's my brother's birthday. Okay, let's not put it on that date if I don't mind. That's appropriate. How about November? Okay, thank you, court reporter. Thank you. We're adjourned. That was the whole hearing.